Hello everybody, welcome to iExamBee's Legal Beat. This is Amrita, your law faculty here at iExamBee. Embrace the iExamBee learning experience with us, and if you're preparing for any competitive examination after your law, then you're at the right place. In this video series, I'm continuing with my descriptive answer writing question practice, and this is very helpful for your exam preparation, especially SEBI Grade A Legal Officer exam. You can discuss your doubts and queries with us in the comment section of this video as well. And you can also take these sample answers, download them. In questions को पहले note down करके आप answers लिख लीजिए. Then you can cross check your answers with the answers that have been provided by us. What all points have been covered? What is the system of writing? All of these steps will definitely help you out. This will also act as a revision for you on that particular question and topic. If you have any queries, you can also write us an email on hello@iexamby.com. and call us on the number 9205524028. Visit our website www.iexamby.com and check out all the online courses available. Even you can activate the demos and check out the course details. Don't forget to subscribe to our YouTube channel LegalBee and stay tuned with us. Prepare 50% faster with us. How to write descriptive answers and sample answers being discussed. This is a very beneficial series for everyone, and this is my 24th part of the series. Distinguish between primary evidence and secondary evidence. When secondary evidence is relating to a document, when it can be given. This is what is the question, very important from Evidence Act. Start with the introduction. Section 61 to 90A of Evidence Act deals with documentary evidences. यहाँ पे आप ये भी ऐड कर सकते हैं कि documentary evidence क्या होता है, what is the meaning of it. In that you have two categories or two ways. Section 61 deals with the proof of content of documents. It provides that the proof of contents of documents can be proved by primary or secondary evidence. Section 62 and 64 deal with primary evidence, and 63, 65 and 66 deal with the secondary evidence. Primary evidence. Primary evidence means the document produced itself for inspection before the court. It is such that which the law requires to be given first, and secondary evidence can be given in the absence of primary evidence. Because primary evidence is the best direct evidence available, and what the fundamental rules of evidence say, that always accept the best evidence. So direct evidence will always be the best evidence. That is true. So that is what is fundamental. But there are some cases in which secondary evidence may be given relating to the documents. Section 65 enumerates those. The person in possession of the original is not within the reach of the court. If the original is in possession of the opposite party. If the original is lost. When the original deed has already been admitted in the court. If the original is a public document, when the original is not easily movable, when the original consists of many accounts. So there are many cases which you can elaborate here point-wise where the secondary evidence can be given. If it is not movable, it is very bulky, all these things you can mention over here for which you can accept the primary evidence. Primary evidence is original document which is presented to the court for the inspection. Secondary evidence is the document which is not original but those documents which are mentioned in section 63. So now we are talking about the points of distinguishing between primary and secondary evidence. The distinguishing features. The heading you can give over here. I think I have missed that. You can add it. Distinguishing features between primary evidence and secondary evidence. क्योंकि आपको ये फोकस करना है कि आपके क्वेश्चन में क्या पूछा गया है. You have been asked what is it, and you have been asked to distinguish between both primary and secondary evidence. So always remember that your answer should be streamlined as per the question that is asked. If they have asked you what is the meaning and what is the distinguishing feature, then both of the points you have to cover specifically. First you define them, then you distinguish between both. So this first point of distinguishing feature between primary evidence and secondary evidence. Primary evidence is original document presented to court for inspection. Secondary evidence is the document which is not original but those documents which are mentioned in section 63. It is the main source of evidence, primary evidence. Secondary evidence is an alternative source of evidence. Section 62 of Evidence Act defines primary evidence and section 63 of Indian Evidence Act defines secondary evidence. Primary evidence is best evidence and secondary evidence is not because it is secondary in nature. As I have told you, as per the fundamental rules of evidence, direct will be the best one. So always follow the best evidence rule. But in exceptional circumstances, as mentioned in section 65, you can take up secondary evidences. Giving primary evidence is a general rule and secondary evidence is exception to this general rule. Primary evidence is itself admissible, secondary is admissible in the absence of primary evidence. So now with these points of differences, you can conclude your answer that primary evidence is considered to be the higher form of evidence as compared to secondary evidence, which is a substitute of it. जो पॉइंट मैंने आपको बताया है फंडामेंटल रूल्स ऑफ एविडेंस के बारे में, वो भी पॉइंट आप यहाँ पे ऐड करके कंक्लूड कर सकते हैं अबाउट द बेस्ट एविडेंस रूल. Thank you everybody. For more such kind of videos, stay tuned with us and check out all the questions and answers all here at Legal B. Prepare 50% faster with us for various examinations and check out the full course access available even on iExamBees app. Thank you everybody.